Hi everybody, it's Andy and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over the California answer to this question. How does my new spouse or how does my new partner's income affect my obligation to pay child support on kids that I have from prior relationships? The concern here, obviously, for the parent who is paying the support is they don't want their new spouse or their new partner to kind of be dragged in financially to this whole child support kind of situation that they have from before. So this question of how my new spouse or new partner's income kind of affects my obligation to pay for support, that actually is quite common. I have a companion video to this one, which I'll link right over here, that basically goes over this same question except applied to spousal support. So go ahead and take a look at that if that's your situation. But again, for this particular video, we are answering the question of how does my new spouse's income or how does my new partner's income affect my obligation to pay child support on kids that I have from before? So the answer to this question actually is going to be in California Family Code section 4057.5, which I'm going to go ahead and link down below and paste as I always do. And 4057.5 basically says this: as a general rule, your new spouse's income, your new partner's income, does not factor into the child support computation that you owe of the kids that you have from before. So whatever child support you owe on those children, that's going to depend on your income, the other parent's income, as well as the time that the children spend with each parent. I have a series of videos on how to compute child support in California, so if that's something you're concerned with, go ahead and take a look at those videos. They're going to be on my channel as well. But anyway, under 4057.5, the general rule is your new spouse's income, your new partner's income, does not factor into the child support computation to figure out what support you owe on your children from before. However, if you do not include your new spouse's income or your new partner's income, if not including that new income would result in severe hardship to your children, then your new partner or your new spouse's income will be considered. So it's the severe hardship exception. It's very rare, but it actually does happen quite frequently. It's not a typical occurrence, but it is also not rare, I guess. So under Family Code section 4057.5B, B as in boy, which again is pasted and linked down below. Under section B, there are two examples of what severe hardship would mean, I guess. And under those situations, under those two situations that are described, your new spouse or your new partner's income can be considered for the purposes of computing child support for children that you have from before. So those two examples rather, under section B are non-inclusive. There are an infinite number of possible severe hardship kind of situations. It all just depends on the facts of your case, the arguments the lawyers make, the judge's decision, things like that. But under section B, the two kind of explicit examples are basically this. Number one is if the parent who's paying support, if after getting married again, if after moving in with their new partner, they all of a sudden stop working entirely. So their income from before was X. After moving in or after getting married, their income goes from X down to 0. So in that case, that basically cheats the children out of income or out of child support that they should have received because, you know, the parent who was paying it, who was working, just all of a sudden for no good reason just stopped. So in a situation like that, if the parent stops working just to live off their new spouse, the new spouse's income or the new partner's income can be considered for the purposes of child support computations. The second scenario, I guess, or situation is basically the same one except not to that big a degree. So let's say, for example, that a parent is paying support and then they move in with somebody or they get married again and they work still. However, they take reduced hours, they go from full-time to part-time for no real good reason. In that case, if that kind of resulting diminution in the child support, if that causes a severe hardship, the new partner's income, the new spouse's income can most definitely be considered. So hopefully that made sense. If you watch the spousal support video over here, answering this same kind of question, that one is a much brighter line rule. Basically, new spouse's income, new partner's income cannot be considered, period, when it comes to computing alimony. For children, it's similar. However, there is an exception. If, again, it's the severe hardship exception. If severe hardship is going to result to the children, the new partner's income or the new spouse's income can be considered. So hopefully that made sense. You guys, if you want to watch this video again, you certainly can. But the applicable law here for children at least is Family Code Section 4057.5. And the one for spouses, if you're looking at the spousal support one, is 4323B of the Family Code, California Family Code. So hopefully that made sense. I tried to explain that as best as I could. But again, watch this video again, leave me a comment if you want. And until then, I will talk to you guys next time. Thanks.